Now, in this class, let us know about the vicarious liability. So, what is the difference between servant and independent contractor? A servant and an independent contractor both do the work at the behest of another person, and thus, what shall be done is not decided by them but by some other person. And thus, on the face of it appears that both are in the same category, and a master should be liable for the torts committed by both of them. But there is a difference between the two which separates them, and consequently, while in case of tort by servant, the master is liable, but in case of independent contractor, the master cannot be held liable. So, in case of servant, there is a contract of service, which means that along with instructing what task should be done by the servant, the master also has the right to instruct the manner in which that has to be done. And thus, the servant does not have autonomy in performance of his duties. So the illustration whereby we can see P is the owner of a newspaper in which many editors are working. Here P as the owner has the right of telling them which news should be covered and how it should be written. So various ways in which liability of master arises. A master becomes liable in the following situations: when wrong done as a natural consequences of an act by servant for master with due care. So if the employee does an act which is done in pursuance of the instruction of the master, so when he has done some work whereby the master has clearly instructed him according to the instructions of the master, the employee has done his work, then the master will be held liable for any wrongs which arises out of such an act, even if all due care is taken by the employee in discharging his work. So we have a case law in Gregory versus Piper, 1829. The defendant and plaintiff had some disputes between them, and the defendant therefore ordered his servant to place rubbish across a pathway to prevent the plaintiff from proceeding on that way, and the servant took all care to ensure that no part of it was touching the part of the plaintiff's property. But with the passage of some time, the rubbish slided down and touched the walls of the plaintiff, and thus he sued for the trespass. So the defendant was held liable despite his servant taking all due care about it. So this was Grigori versus Piper case law. And the next one is said to be wrong due to negligence of work. So what is wrong due to negligence of work? A master is also liable for an act of the servant which he does negligently, or certain times he fails to take due care in carrying out. So we have a case law in Pushpabai Purushottam Udeshi and others versus Ranjit Ginning and Pressing Company. The deceased was traveling in a car driven by the manager of the respondent company, and it met with an accident, as a result of which he died. So here the dependents of the deceased filed a claim, and the tribunal allowed damages, but on the appeal to the High Court, it was set aside on the ground that the accident does not make the respondent company liable, but the Supreme Court, in its judgment, overruled the judgment of the High Court and held that from the facts of the case, it was clear that the accident had occurred due to the negligence of the manager, who was driving the vehicle in the course of his employment, and therefore the respondent company was held liable for his negligent act. We can see an illustration also in this case. If H works as a house cleaner of K, then there is a master and servant relationship between them. But if H, instead of cleaning the house, decides to cook food, even though he has only been hired for cleaning the house, and due to his negligence causes a fire, which also causes loss to K's neighbor who's considered as L in this illustration, and then K will not be held liable because H did an act which was outside the course of his employment. So if H works as a house cleaner for K, then there is a master and servant relationship which exists between the H and K. And if H, instead of cleaning the house, decides to cook food, even though he has only been hired for cleaning the house. So, due to his negligence, it causes a fire, which also causes loss to K's neighbor L. Then K will not be held liable because H did an act which was outside the course of his employment. So the next the next point would be wrong by excess or mistaken execution of a lawful authority. So for making the master liable in such a case, it has been shown that the servant had intended to do an act on behalf of his master, which he was authorized to do. The second point is the act would have been lawful if it was done in those circumstances which the servant mistakenly believed were true, or if the act would have been lawful if done properly. So in Bailey versus Manchester's S and L Railway, 1873, a porter of a railway company, while working mistakenly, believed that the plaintiff was in the wrong carriage, even though he was in the right one. So the porter thus pulled the plaintiff, as a result of which the plaintiff sustained injuries. Here, the court held the railway company vicariously liable for the act of porter because it was done in the course of his employment, and this act would have been proper if the plaintiff was indeed in wrong carriage. In Anita Bandari and others versus Union of India, So the husband of the petitioner went to a bank, and while entering inside it, the cash box of the bank was also being carried inside. And as a result, the security guard, in a haste, he shot him and caused his death. So the petitioner had claimed that bank was vicariously liable in the case because the security guard had done such act in the course of employment, but the bank had contended that it had not authorized the guard to shoot. So the court held the bank liable as the act or giving him a gun amounted to authorizing him to shoot when he deemed it necessary. And while the guard had acted overzealously in his duties, it was still done in the course of employment. And yes, of course, the bank is held liable in this case. So the next one point would be the wrong committed willfully by a servant with the intention of serving the purpose of the master. In Limpers versus London General Omnibus Company, 1862, the driver of the defendant company willfully and against the express orders not to get involved in racing or to obstruct other omnibuses had driven to obstruct the omnibus of the plaintiff. In the case, the court held that the defendant company was liable for the act of the driver because the driver's act of driving the omnibus was within the scope of the course of employment. So, in the same way, we have Peterson versus Royal Oak Hotel Limited, 1948. So, here the plaintiff was a customer who, on being intoxicated, was refused further drinks by the barman who was employed under the respondent, and thus the plaintiff threw a glass at him. The barman took a piece of the glass and threw it at him, which hit his eye. So the respondent hotel was held liable due to the act of the barman who had a master and servant relationship with them. So the next point would be wrong by servants fraudulent act. So a master can also be held liable for a fraudulent act of the servant. In Lloyd versus Grace Smith and Company, 1912, so the plaintiff was a widow who owned £1,000 as due on a mortgage and a cottage. She went to the manager of the defendant, which was a firm of solicitors, and she asked for his advice to get richer. So the manager told her to sell her cottage and to call up the amount of mortgage. She authorized the manager to sell the property and to collect her money, but he absconded with the money. Thus, she sued the defendant company. It was held that the defendant was liable for the fraudulent act of the manager because even though a fraudulent act is not authorized, the manager was authorized to take her signature, and thus it was within the course of employment. So the illustration, if A goes to a bank and deposit a check with C, an employee of the bank and C fraudulently transfer that amount to his wife's account. Here, for the fraudulent act of C, the bank will be liable. So the conclusion is that So we have to come to the conclusion under vicarious liability. A person can be held liable for the torts committed by another person if that person shares a master-servant relation with him. So that servant does the act on behalf of his master, and therefore the law of torts provides that any wrongful act which is done in the course of employment by the servant is bound to make the master liable for it. So there have been several tests for determining the relationship of master and servant, and the court also applies its discretion according to the facts of the case to determine such a relationship. So thank you, and it is all about the vicarious liability, the master and servant relationship, and when they are said to be held liable, and what cases they are held liable, and in what circumstances they are not held liable. Thank you.